All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and court practice for immersion. The courtroom air feels thick as Defense Attorney North stands at the podium, her fingertips resting on the edge of the lectern, her client seated 20 feet behind her at the defense table. Judge Keystone leans forward on the bench, reading glasses perched low on his nose, scanning a single sheet of paper that has just been handed to him by the clerk. The gallery is packed, family members in the front 2 rows, a few reporters near the back, and everyone senses something has shifted in the last 60 seconds. This was supposed to be a straightforward sentencing hearing, the kind where the judge announces a mid-range term, everyone exhales, and the deputies escort the defendant out to begin serving time. But now the prosecutor, a woman named Slate, is standing at her table with a manila folder open, and North's jaw is set in a way that says she did not see this coming. The defendant, a man in his late 30s known in this record as Rook, sits motionless in an orange jumpsuit, his hands folded on the table, his eyes fixed on the judge. Judge Keystone removes his glasses, sets them down, and speaks in a measured tone that somehow carries more weight than volume. "Counsel, we need to address this prior conviction before I proceed." The room goes silent, and in that silence, the promise of mercy that hung over this hearing just moments ago begins to crack. 20 minutes earlier, this sentencing felt like a done deal. Rook had entered a guilty plea to a single count of possession with intent to distribute a controlled substance, a serious charge, but one that carried a sentencing range under the federal guidelines of 63 to 78 months, if the judge calculated his criminal history as Category 2. North had filed a detailed sentencing memorandum 3 weeks before today, laying out the mitigating factors: Rook's difficult childhood, his efforts at rehabilitation during pre-trial supervision, letters from family members attesting to his character, and a substance abuse evaluation recommending treatment rather than prolonged incarceration. She had met with Rook a dozen times in the holding cell beneath the courthouse, walking him through what to expect, coaching him on how to address the court if given the chance, reminding him that the judge had discretion to go below the guideline range if the circumstances warranted it. The prosecutor, Slate, had not opposed a low-end sentence in her own filing, noting that Rook had cooperated to some degree during the investigation and that his role in the distribution network was relatively minor. Even the probation officer who prepared the pre-sentence investigation report had recommended a sentence toward the lower end of the range, citing Rook's lack of violent history and his expressed remorse. Everything pointed toward leniency, and North had allowed herself to believe that her client might walk out of this hearing with 5 years, maybe even less, if the judge granted a departure. If you found this story compelling, make sure to subscribe and share your thoughts in the comments. We'll keep bringing you these deep dives into how the justice system really works. But just before the hearing formally began, Slate had approached the bench with a single-page document and asked for a sidebar. North joined her, and the 2 attorneys stood at the side of the judge's bench, speaking in low tones while the court reporter angled her machine to capture every word on the record. Slate explained that her office had received updated information from the National Crime Information Center database late the previous afternoon, a prior conviction out of Granite County, nearly 12 years old, that had not appeared in the initial background check because it had been filed under a slightly different variation of Rook's name. The conviction was for aggravated assault, a crime that qualified as a crime of violence under the federal sentencing guidelines. If that prior conviction was deemed valid and applicable, it would bump Rook's criminal history category from 2 to IV, pushing the guideline range up to 97 to 121 months, a significant jump. More troubling still, it might trigger the career offender designation under Guideline 4B1, which requires 2 prior felony convictions for crimes of violence or controlled substance offenses. Rook already had 1 drug-related conviction from years ago, and if this aggravated assault counted as the second qualifying conviction, his sentencing range would skyrocket to 210 to 262 months. North felt the floor tilt beneath her as Slate laid out the implications. She asked for time to investigate the validity of the prior conviction, to review the Granite County records, to determine whether the offense truly met the federal definition of a crime of violence. Judge Keystone granted a brief recess, instructing both counsel to return in 15 minutes prepared to argue the issue. North raced down the hall to a small attorney conference room, pulling up the Granite County online docket on her laptop. The case was there. 12 years ago, Rook had been charged with aggravated assault after a bar fight that left another man with a broken jaw. He had pleaded guilty to a reduced charge and served 18 months in county jail. The statute under which he was convicted required proof of knowingly causing serious bodily injury to another person, which on its face seemed to fit the federal definition of a crime of violence. But North knew that the categorical approach, the method courts use to determine whether a prior conviction qualified, required her to look at the elements of the state offense, not the facts of what actually happened. If the state statute was broader than the federal definition, sweeping in conduct that would not be considered violent under federal law, then the prior conviction might not count. She found the Granite County statute, read it twice, and felt her heart sink. The language was narrow and specific, tracking almost exactly the federal definition. Unless she could find a procedural defect in the way the conviction had been obtained, a lack of counsel, an invalid plea, something, the prior conviction would stand, and her client would face a sentence nearly 4 times longer than what she had expected. Back in the courtroom, North makes her argument at the podium, her voice steady but edged with urgency. She concedes that the prior conviction exists, but argues that the court should exercise its discretion to vary downward from the career offender guideline, pointing out that the offense occurred over a decade ago, that Rook has not engaged in violent conduct since, and that the purposes of sentencing, punishment, deterrence, rehabilitation, would not be served by treating him as a career offender. She cites the parsimony principle, the statutory command that a sentence be sufficient, but not greater than necessary, to achieve the goals of sentencing. She reminds Judge Keystone of the mitigation evidence she has submitted, the letters from Rook's mother and sister, the substance abuse counselor's recommendation. She appeals to the judge's sense of fairness, noting that the prior conviction only came to light at the 11th hour, depriving the defense of a meaningful opportunity to investigate or challenge it. Judge Keystone listens without interruption, jotting notes on a legal pad, his expression unreadable. When North finishes, Slate rises to respond. She acknowledges the defendant's mitigation, but emphasizes that the guidelines exist for a reason, to ensure uniformity and predictability in sentencing. She points out that Rook's criminal history is more serious than the defense has suggested, that the aggravated assault involves significant violence, and that his repeated involvement in drug offenses demonstrates a pattern of unlawful behavior. She argues that the career offender designation is not a prosecutorial choice, but a legal determination based on the defendant's record, and that the court is bound to apply it unless extraordinary circumstances warrant a departure. Judge Keystone asks a single question. Ms. Slate, do you have any reason to believe the prior conviction was not properly obtained? Slate answers firmly, no, Your Honor. The defendant was represented by counsel, entered a knowing and voluntary plea, and was sentenced by a court of competent jurisdiction. Judge Keystone leans back in his chair, folding his hands across his chest, and the courtroom waits. The judge has a reputation for fairness, for carefully weighing the law against the humanity of the people who appear before him, but he also has a reputation for following the guidelines unless the record compels him to do otherwise. After a long pause, he speaks. I have reviewed the presentence report, the parties' sentencing memoranda, and the supplemental information provided by the government regarding the prior conviction. Based on the categorical approach and the elements of the Granite County statute, I find that the defendant's prior conviction for aggravated assault qualifies as a crime of violence under Guideline 1B1. 2. Combined with his prior drug conviction, this establishes the defendant as a career offender under Guideline 4B1. 1. North feels the blood drain from her face. The judge continues. The applicable guideline range is therefore 210 to 262 months. I have considered the defense's request for a downward variance, and I acknowledge the mitigating factors presented. However, the defendant's criminal history reflects a pattern of serious and escalating conduct. This is not a case of youthful indiscretion or isolated mistake. The defendant has had multiple opportunities to change course, and he has not done so. I find that a sentence within the career offender range is necessary to reflect the seriousness of the offence, promote respect for the law, provide just punishment, and deter future criminal conduct. He pauses, glancing down at Rook, and then delivers the sentence that will echo through the appeals process for the next 2 years. The defendant is hereby sentenced to 240 months, 20 years, in the custody of the Bureau of Prisons, followed by 5 years of supervised release. The gasp from the gallery is audible, a collective intake of breath that ripples through the rows. Rook's mother stands halfway, then sits back down, her hands covering her mouth. North grips the podium, her mind already racing through the procedural steps for an appeal. Slate closes her folder, her face impassive. Judge Keystone strikes his gavel once, and the deputies move forward to take Rook into custody. The shock in the courtroom is not just about the length of the sentence, it is about the sudden, brutal shift from mercy to maximum time based on a single prior conviction that no one in the room, except Slate, knew existed until an hour ago. The defense team had prepared for a 5-year sentence, maybe 7 at the outside. Instead, Rook will not be eligible for release until he is nearly 60 years old. As the deputies lead him toward the side door, Rook glances back at his mother, his face a mask of disbelief, and she mouths something that might be "I love you" or "I'm sorry." North gathers her papers, her hands shaking slightly, and walks back to the defense table. She knows that the law, as applied, is technically correct. The career offender guideline is mandatory unless the judge finds a basis to depart, and Judge Keystone concluded that the mitigating factors did not outweigh the seriousness of the criminal history. But she also knows that something about this feels wrong, that a 12-year-old conviction for a bar fight should not be the hinge on which a man's entire future turns, and that the system's insistence on uniformity has just produced a result that strikes nearly everyone in the room as unjust. The reporters in the back are already typing on their phones, and by the end of the day the local news will carry the story. Judge imposes 20-year sentence after last-minute discovery of prior conviction. Within a week, North files a notice of appeal, and the case begins its slow journey through the appellate system. The 10th Circuit Court of Appeals, which reviews federal sentences from this district, will eventually take up 3 issues. Whether the district court correctly applied the categorical approach to determine that the prior conviction qualified as a crime of violence, whether the court abused its discretion by declining to vary downward from the career offender range, and whether the government's failure to disclose the prior conviction until the day of sentencing violated the defendant's due process rights. North spends months researching case law, drafting a 60-page brief that argues the Granite County statute is broader than the federal definition because it includes reckless conduct as well as knowing conduct, and that at least some convictions under that statute would not qualify as crimes of violence under the categorical approach. She also argues that the district court gave insufficient weight to the mitigation evidence and that the sentence is substantively unreasonable given the totality of the circumstances. Finally, she raises the due process argument, pointing out that the government had access to the National Crime Information Center database from the beginning of the case, that it could have run a more thorough background check, and that the last-minute disclosure deprived the defense of a fair opportunity to investigate the validity of the conviction or to prepare a more robust argument for a downward departure. The government's response, filed by an appellate attorney in the U.S. Attorney's Office, defends the district court's application of the categorical approach, arguing that the Granite County statute unambiguously requires knowing conduct and that the defendant has not pointed to any case in which a conviction under that statute was obtained based on reckless conduct alone. The government also argues that the district court's decision not to vary downward was well within its discretion, given the defendant's criminal history and the seriousness of the offense. As for the due process claim, the government contends that there is no constitutional right to advance notice of a prior conviction, that the defendant had an opportunity to challenge the conviction at the sentencing hearing, and that any delay in disclosure was inadvertent rather than intentional. The briefing is completed, and oral argument is scheduled for a morning session in the spring. North appears before a 3-judge panel, standing at the podium in a wood-paneled courtroom, in the federal courthouse in Riverbend, answering rapid-fire questions about the scope of the Granite County statute, the standard of review for sentencing challenges, and whether the defendant preserved his due process objection at the district court level. The judges press her hard, and she leaves the courtroom uncertain of the outcome. 6 months later, the 10th Circuit issues a published opinion. The court affirms the district court's determination that the prior conviction qualifies as a crime of violence, holding that the categorical approach requires examination of the statute's elements, not the specific facts of the defendant's conduct, and that the Granite County statute is a categorical match for the federal definition. The court also affirms the district court's decision not to vary downward, noting that sentencing judges have broad discretion and that the career offender guideline is designed precisely for defendants with the kind of criminal history that Rook has. But the appellate panel does not stop there. In a separate section of the opinion, the court addresses the due process issue and finds that the government's failure to disclose the prior conviction until the day of sentencing, while not rising to the level of a constitutional violation, was troubling and inconsistent with the government's obligation to ensure a fair sentencing process. The court notes that the defendant was prejudiced by the late disclosure, as he did not have a meaningful opportunity to investigate the conviction or to present evidence that might have undermined its validity. The court declines to reverse the sentence on this basis alone, but it remands the case to the district court with instructions to hold a new sentencing hearing at which the defendant will be given a full and fair opportunity to challenge the prior conviction and to present additional mitigation evidence. The opinion concludes with a pointed reminder. While the government is not required to conduct exhaustive background checks in every case, it has a duty to disclose information that is material to sentencing in a timely manner, particularly when that information will have a dramatic impact on the defendant's guideline range. The remand sends the case back to Judge Keystone's courtroom, and this time, North is prepared. She hires a private investigator to travel to Granite County and obtain the complete file from Rook's prior case, including the police report, the plea colloquy transcript, and any statements made by Rook or his attorney at the time. The investigator uncovers a detail that changes everything. At the plea hearing 12 years ago, Rook's attorney had argued that the conduct was reckless rather than knowing, and the prosecutor had agreed to accept a plea to the aggravated assault charge on the understanding that the factual basis would reflect reckless rather than intentional conduct. The plea colloquy transcript shows the judge asking Rook whether he recklessly caused serious bodily injury, and Rook answering yes. Under the categorical approach, if the conviction was based on reckless conduct, it does not qualify as a crime of violence because the federal definition requires intentional conduct. Armed with this evidence, North files a motion to strike the prior conviction from Rook's criminal history calculation. At the new sentencing hearing, she presents the plea transcript and argues that the conviction does not meet the federal standard. Slate, clearly frustrated, argues that the plea colloquy is ambiguous and that the court should not second-guess the original plea. But Judge Keystone, visibly more cautious this time, agrees with North. He finds that the prior conviction was based on reckless conduct and therefore does not qualify as a crime of violence under the categorical approach. As a result, Rook is no longer a career offender, and his guideline range drops back down to 63 to 78 months. Judge Keystone sentences Rook to 72 months, 6 years, crediting him for the time he has already served while the appeal was pending. Rook, who has been in custody for nearly 4 years at this point, will be released in just over 2 years. The reversal sends ripples beyond this single case. The local news picks up the story again, this time framing it as a cautionary tale about the dangers of relying on last-minute information and the importance of thorough investigation. Defense attorneys across the district begin requesting full criminal history records earlier in the process, and the U.S. Attorney's Office issues an internal memo instructing prosecutors to run comprehensive background checks at the outset of every case and to disclose any prior convictions as soon as they are discovered. Judge Keystone himself becomes more skeptical of career offender designations, requiring detailed briefing and evidentiary hearings whenever a prior conviction is contested. The case also attracts the attention of sentencing reform advocates, who point to it as an example of how mandatory guidelines and enhancement provisions can produce unjust results, particularly when they rely on decades-old convictions that may not accurately reflect a defendant's current conduct or character. Some argue for legislative changes to limit the reach of the career offender guideline, to require that prior convictions be recent and directly relevant to the current offence, or to give judges more discretion to depart downward when the guideline range seems excessive. Others defend the guideline as a necessary tool for ensuring that repeat offenders face serious consequences, but they acknowledge that the system must allow for individualized consideration of mitigating factors. For Rook, the journey through the sentencing process has been a lesson in how much can turn on the discovery and interpretation of a single prior conviction. When he first stood in Judge Keystone's courtroom and heard the 20-year sentence, he believed that his life was over, that he would spend the next 2 decades in a federal prison, watching his family age through video calls and rare visits. The appellate process gave him a second chance, not because the law changed or because the judge had a change of heart, but because the defense team dug deeper and found a factual record that undermined the government's characterization of the prior conviction. The experience has also left him with a more complicated view of the justice system, one that recognizes both its capacity for correction and its vulnerability to procedural errors and incomplete information. He completes his sentence, enters a halfway house and begins supervised release with a determination to stay out of the system for good. His mother, who sat through both sentencing hearings and never stopped believing in the possibility of a different outcome, tells him that the ordeal has taught her something too, that the law is not as fixed or as impersonal as it seems, that every sentence is the product of human decisions and human mistakes, and that persistence and scrutiny can sometimes change the result. North, for her part, carries the case with her as a reminder of why the work matters. She has handled hundreds of sentencings over the course of her career, and most of them follow a predictable arc. The client pleads guilty, the guideline range is calculated, the judge imposes a sentence somewhere in the middle, and everyone moves on. But this case was different. It forced her to confront the machinery of sentencing enhancements, to wrestle with the categorical approach and the career offender guideline, and to fight for a client who came within a single prior conviction of losing 20 years of his life. It also reinforced her belief that defense attorneys have a duty to investigate every aspect of a client's criminal history, to challenge every assumption, and to hold the government accountable for the accuracy and timeliness of the information it provides. The appellate victory was not a vindication of Rook's innocence. He was, after all, guilty of the underlying offense, but it was a vindication of the principle that sentencing must be based on accurate facts and sound legal reasoning, and that when the process fails, the appellate courts have the power and the responsibility to correct the error. The courthouse in Riverbend is quiet now. The morning docket finished, the gallery empty except for a clerk gathering files and a janitor pushing a cart down the aisle. Judge Keystone sits alone in his chambers, reviewing the opinion from the 10th Circuit one more time, annotating the margins with notes for future reference. He has always prided himself on getting the law right, on applying the guidelines faithfully and fairly, but this case has shown him how much can depend on the timing and completeness of the information before him. The first sentencing, 20 years based on a career offender designation, was legally correct given the record as it existed at the time. But the second sentencing, 6 years after the prior conviction was re-examined and found not to qualify, was also legally correct, and the 18-year difference between the two outcomes turned entirely on a detail buried in a 12-year-old plea transcript that no one had bothered to review until the appellate court sent the case back. The experience has made him more cautious, more willing to question the government's characterization of prior convictions, and more attuned to the human consequences of the technical rules that govern sentencing. He knows that the system relies on judges to exercise discretion wisely, to balance the demands of uniformity with the demands of justice, and to recognize when a rule that makes sense in the abstract produces an unjust result in a particular case. He also knows that the system is only as reliable as the information on which it is based, and that when that information is incomplete or inaccurate, even the most careful legal analysis can lead to the wrong result. If this kind of in-depth courtroom storytelling resonates with you, hit the subscribe button and let us know in the comments what other legal procedures or cases you'd like us to explore. The case of Rook teaches a broader lesson about sentencing in the American criminal justice system. Prior convictions are powerful tools for prosecutors, capable of transforming a mid-level sentence into a decades-long term of imprisonment through enhancement provisions like the career offender guideline. But those tools are only as just as the process by which they are applied. When prior convictions are disclosed late, when they are not thoroughly investigated, or when they are characterized in ways that do not match the factual basis for the original plea, the result is a sentencing process that feels arbitrary and punitive rather than fair and reasoned. The categorical approach, which requires courts to look at the elements of a prior offense rather than the specific facts of what the defendant did, is designed to promote consistency and prevent judges from relitigating old cases. But it also creates opportunities for error, particularly when the elements of a state statute are ambiguous or when the factual basis for a plea is not clearly documented. Defense attorneys have a critical role to play in identifying these errors, in demanding access to complete records, and in challenging the government's interpretation of prior convictions at every stage of the process. Judges, too, have a responsibility to scrutinize the information before them, to ask hard questions about the basis for enhancement designations, and to ensure that sentences are not only legally correct, but also substantively fair. The story ends not with a dramatic courtroom confrontation or a last-minute reversal, but with the quiet, methodical work of appellate review and resentencing, the kind of work that rarely makes headlines, but that shapes the lives of defendants and the integrity of the justice system. In the end, Rook's sentence was reduced not because the law changed or because the judge had mercy, but because the defense team uncovered a factual record that the government had overlooked, and because the appellate court insisted that sentencing must be based on accurate information and sound legal reasoning. The 20-year sentence that shocked the courtroom was replaced by a 6-year sentence that, while still significant, reflected a more accurate assessment of Rook's criminal history and a more careful application of the categorical approach. The courthouse has returned to its daily rhythm, but the case remains in the case law, a published opinion that defense attorneys and prosecutors will cite for years to come. A reminder that even in a system governed by guidelines and mandatory enhancements, there is room for correction, for scrutiny, and for justice to prevail when the process is allowed to work as it should.